Alrighty, thank you, Nick. I think we just got in before Nick expired there, so that was good timing. It's good to be back. I haven't presented to the BICB for a couple of years. And today I'm going to talk about a topic that sort of follows on from what Nick was talking about. Now, unfortunately today, guys, I don't have any slides, so sorry about that. Some technical difficulties on my end. So we're going to do it a cappella. We're going to just have to try and follow along, and I'll do my best. So today we're going to talk about something that I think is going to become increasingly relevant over the next couple of years. As Nick's mentioned, we don't know when these insolvencies are going to come. We don't know if it's going to be tomorrow and it's going to be a massive wave. It's probably not going to be. We don't know if it's going to bleed over the next couple of years, but we do know that they are going to come, and we know that from looking at the data and the trends over the last 10 years of insolvencies. And what I want to talk about off the back of that is overcoming the abuse of insolvency laws by related party creditors. So Nick talked a lot about the new insolvency regimes for small businesses and simplified liquidation processes. I'm going to be talking about the more traditional voluntary administration process, and more importantly, the processes of deeds of company arrangement and how they can be abused by directors. So I'm pretty sure everyone in the room and playing at home has encountered situations where dodgy directors have thrown their companies into liquidation or administration, and they've effectively walked away scot-free. You're left there holding a debt, and they've miraculously phoenixed their company or are otherwise trading as per usual, and there's just no real recourse there. And one of the key ways that this happens is through the abuse of the deed of company arrangement, or DOCA, as I'm going to refer to it, regime. And in that regime, as we'll see, directors can not only dispose of creditors' claims and retain control of the company, but they can just go on like nothing really happened. It's pretty cool if you're a director. So this is nothing new. Directors have been doing this for 20 years. However, we've certainly seen it start to gather steam over, say, the last 5 to 10 years, and that's for a couple of reasons. I think the awareness of what people can do or what directors can do is just coming more to the fore. There's an increase in pre-insolvency or Phoenix advisors, and I think it's just more topical, so it just seems to be coming up a lot more, and people are taking advantage of the situation, and I say that in a negative sense. But the reason why we thought it'd be a bit interesting today is with COVID and with these this tidal wave or this tsunami, whenever it comes, of insolvencies, it's a slightly different situation, because here the directors have had at least, say, 12 months of seeing the writing on the wall. So there's been a really long lead time for a lot of companies to see what's happening, and to start to think about, oh wow, when, say, JobKeeper disappears, or when some of the statutory demand restrictions lift, I could be in real trouble here. So they've had a lot of time to think about it. And whilst a lot of directors will do the right thing and say, look, I'm just going to sail off into liquidation where I belong and go quietly, some of them are going to look to take advantage of this situation and have really been planning for it. And I'll get to that in a moment, but just to give you an idea about when we're talking about these insolvencies coming, just a quick number, the ATO on average filed about 150 wind-ups per year last year, and they've largely been on hold for about 12 months now. So if we add those back in and assume that, at the very least from the ATO alone, there's going to be 150 a month, there could be 300 a month to play catch up with. Now, they're not all going to drop at once, but the point is they are there, they are going to come. And that's pretty significant. So we've got these two categories of directors. We've got the directors who are just going to let their companies fall into liquidation, and we have to go through that unhappy process. So be it. But today we're going to talk about the ones who have been planning and who have arranged their affairs to potentially take advantage of the DOCA regime. So quick show of hands, has everyone in the room at least been exposed to deeds of company arrangement and know how they play out? I'm going to do a quick run through for everyone playing at home anyway. So a deed of company arrangement is effectively a proposal made to the creditors of a company, which is an alternative to it being placed into liquidation. It's a flexible tool that is used to save a company from collapse. And once it's approved, it's really an agreement between the creditors and the company, which will allow the company to continue in existence. So in an administration process, a DOCA is one of three options available to creditors. The other two are: one, handing the control of the company back to the directors, usually if the company is solvent, or more likely and more commonly than not, placing the company into liquidation. So it's one of those three. So the aim of the DOCA is to maximise the chance for the company to continue, or to provide a better return to creditors than they'd otherwise receive in a liquidation. And ordinarily, and when I say ordinarily, I mean 99.9% of the time, this involves creditors willingly compromising their claims. And I'm sure you've all seen that. The report to creditors that says that you've won the grand prize of getting 3 cents in the dollar or something like that. Congratulations. Who is bound by a deed of company arrangement? Well, a DOCA binds all unsecured creditors, even if they voted against the proposal. It also binds owners of property who lease property to the company, and secured creditors to the extent that they're not secured, or alternatively, if they vote in favour of a DOCA. And in certain circumstances, DOCAs can also bind secured creditors that didn't vote for it. As you may know, a DOCA does not prevent a creditor who holds a personal guarantee from enforcing that guarantee, although there may be some restrictions prior to the DOCA being entered into under the administration process. So, in an ideal world, a deed of company arrangement kind of works well. It's a great idea. And generally speaking, you know, there are benefits. It can ensure a better return to creditors than they'd otherwise get in a liquidation. As we know, liquidations can have some fairly significant costs, and that can reduce the money that would be available to creditors. It can allow for businesses which, you know, are good businesses fundamentally and may have just had a rough run, for example, with COVID, to continue, and that's obviously a benefit to the economy as a whole. If you're a director, on the other hand, it's fantastic. I mean, you get to get rid of debts for less than 100 cents in the dollar. You protect yourself from scrutiny by a liquidator, any insolvent trading claims, any voidable transaction claims. There's certain tax advantages that can be gotten. So, look, there's pros and cons, and fundamentally as a whole, the DOCA regime is great and it certainly has its place. But what we're talking about today is how it can be abused. And I guess a good recent example of the DOCA regime working really well is with Virgin Australia. That process enabled us to retain a second major airline, which competition alone, fantastic for consumers. They've come out really well on the other end. Qantas, not so stoked about it. They saw a real opportunity there, and now they've got a competitor that is much freer of debt. So you can understand why competitors faced with a company coming out the other side of a DOCA can be a bit miffed, but generally speaking, there's some real benefits there. So, abuse of DOCAs though. In order for a DOCA to be accepted by creditors, it requires a vote by 50% of the creditors by value and 50% by number. If there's a deadlock, the administrator can exercise a casting vote or apply to the court for directions, or it can be deadlocked and the company will go into liquidation. This is great in theory because, I mean, if a DOCA is not favourable to unsecured creditors, you just don't vote for it, right? And that's easy. You're going to win the vote, happy days. Not so in practice. And here is the real kicker. Because there's no prohibition against parties related to a director or even controlled by a director voting in a DOCA. Particularly in small to medium enterprises, it's not uncommon at all to see a significant number of director-related creditors pop up in an administration. And sometimes it's by chance, and sometimes it's by design, but the point is you'll come across DOCAs where related parties do control the vote. And what's even worse is, I'll refer to it as vote stacking, and this is something that's becoming increasingly prevalent with pre-insolvency advisors, and it ties into this idea of directors planning for such an eventuality. But it's a situation where a company takes steps in the lead up to their administration to make sure that they're going to control that vote. All of a sudden, your mum, your uncle, your sister, your brother, and a few other companies beside all have lodged proof of debts in the company. They've all lent money. Sometimes it's only small amounts because you need 50% by value, 50% by number. So sometimes there's just a lot of small amounts just to get that number up. And sometimes there'll be large amounts of related party claims, your classic being your director's loan to the company or something like that. But all of a sudden you've got a company whose vote is going to be controlled entirely by related parties. And something that we'll talk about later and is again that even if directly related parties aren't enough to control the vote, it's very, very common for directors or whoever's going to propose the DOCA to go buy more votes. And by buy more votes, I mean go to problematic creditors, whisper in their ear and say, hey, the DOCA is going to pay 3 cents. Tell you what, I'll give you 50 cents, cut a deal, you vote for the DOCA, happy days. Those creditors are going to take that, and we'll get on to that in a little bit because it can be a really, really good option for individual creditors, terrible for the credit pool as a whole because that dodgy DOCA is going to get up. So yeah, whether they're directly related or related by way of an agreement, you can have situations where all of a sudden deeds of company arrangement, which on their face look absolutely terrible, get voted up. So let's play that situation out. A DOCA is voted up, maybe it's terrible for you, it's 1 cent in the dollar, maybe you get nothing. So what do you do? Well, to be perfectly honest, in a lot of situations, you probably do nothing. The reality is stuff like this costs money. Maybe your debt's small. Maybe you've just got so much more on, it's just not worth your time and investment. And it's better just to move on to the next job rather than crying over spilt milk. That's just a reality. What I'm talking about are the times when you do have a significant debt or there is some other commercial reason why this matter is of particular interest to you. The situations where, and also probably the real critical one is where you know something's going on. Something just doesn't seem right. Maybe you've read the administrator's report and all of a sudden this company that you know has a heap of plant and equipment, magically that report isn't referred to, that equipment's not referred to in the report at all. So you're thinking to yourself, well, how does this company, which I know has got some cash, I know the directors are cashed up, or I know the directors Phoenix the business, how are they only offering us 1 cent in the dollar? All of a sudden you get to the vote on the DOCA and related parties. The vote's over before it even begins. They control it, it goes through. So you're stuck with a DOCA and maybe your couple of hundred, maybe a couple of $1 million claim is reduced to cents, absolute cents in the dollar, and occasionally in some of the more blatant DOCAs, and I'll go to one later, it may in fact be zero. And deed proponents are very good at crafting DOCAs which they can frame as saying 1 cent in the dollar, but are littered with conditions which in practice will see that 1 cent actually drop to nothing. So it's really a Pyrrhic sort of offer, or a Pyrrhic DOCA. In those situations, it's open to creditors, whether acting independently or in our experience, even more compellingly together, to apply to court to have the DOCA terminated and the company placed into liquidation, where it can be properly investigated and potentially better returns can be made to creditors than would have been had in a liquidation. So the key circumstances in which a company will agree to terminate a deed of company arrangement are where information provided to creditors in the course of the administration was false and misleading. This usually occurs in the administrator's second report to creditors. So on this one, unfortunately, there's some insolvency practitioners out there that are really guns for hire, and you see this really play out in the reports to creditors where they just don't stack up. There's things that are missing. They gloss over huge potential claims in insolvencies. A matter I'll speak about later. We had a report where the director 6 months prior to the liquidation wrote off $3 million of amounts owed to the company by related creditors. That's a pretty serious amount of money. and two related creditors, no doubt, it warranted one tiny line in the report, and that was it. Just to note that the books and records reflect that this amount was written off, the end. And if you don't want to trawl through 48 pages of report, you're going to miss it. So that is a ground for setting aside of DOCAs. Second one is an obvious one. If the DOCA is breached and the terms of the DOCA, which are agreed with creditors, aren't carried out, that's a ground to terminate it. If the DOCA can't be given effect to without delay or without reasonable delay, some DOCAs are designed to stretch on for years and years, and you can terminate them in those circumstances. Or critically for our purposes, if the DOCA is oppressive or unfairly prejudicial or discriminatory against one or more of the company's creditors, or is contrary to the interests of the company as a whole. And that's the one I want to focus on. So in a case run by the tax office, the court put some commentary around that and said essentially that in determining whether a deed is oppressive, it needs to be considered against the background principles of the Act. And a creditor has a basic right to payment to the winding up of the company or to the administration of the company in a manner that keeps the company going, which ultimately results in the creditor receiving payment out of the property of the company. It will look at the whole effect of the deed and assess its unfairness, if any, to the creditor, bearing in mind the purposes of the Act. And it's necessary to consider the total circumstances to determine if there's overall unfairness. So it is a very holistic approach. Now, just to remind you, the objectives of the regime are to maximise the chances of the company surviving and or to ensure that creditors get a better return than they'd otherwise get from an immediate winding up. So the court will look at those and consider whether it's oppressive or not. Now, with respect to DOCAs voted up by related creditors, the court has said that the interest of creditors is referring to the creditors' interests as creditors. It's not to their interests as they are related to the director, it's to their interest as an objective creditor of the company. So if for some reason, in this particular case, 7 creditors who were owed nearly $1 million decided to forego their debts but nevertheless vote for the DOCA, that's not them acting objectively as an independent creditor would. I mean, why would you just waive your $1 million of debts to vote up the company, to vote up the DOCA? So whilst the court says there's nothing untoward with, necessarily untoward with related creditors, acting with that related interest, it's a weighty consideration and the interests of unrelated creditors should prevail. So critically, the court won't let that stand. They won't let deeds of company arrangement be foisted on unrelated creditors unless there is some very, very compelling reason. So I want to give you 2 examples of key matters that we've run in the last few years, which are pretty much the precedent in this area of law at the moment, which is pretty cool. So in the matter of Sales Express, our client obtained a judgment against a company for $1.64 million. 2 months later, surprise, surprise, before we can get paid, company goes into administration. The director proposed a deed of company arrangement where we would get 6 cents in the dollar, probably would have been maybe 4 cents in the dollar. Not particularly great. Under that DOCA, it was voted up by related parties who forfeited about $48 million of debts. So they just said, don't worry about us. We want to vote, but we're going to waive our debt so we won't get anything. Happy days. And the effect of the DOCA was that critically, it would have avoided the investigation of the company divesting itself of 100 plus registered trademarks. And these were valuable registered trademarks for commercial goods that you can buy in, your hardware stores and the like. So our client was nearly the sole unrelated creditor. He applied to court. And the court ultimately found that the voices of minority unrelated creditors should prevail over related creditors, particularly where they'd agreed not to receive any distribution. And the court found that the director was abusing the provisions. So really it created this rule, the related creditor rule, that says that, related creditors' views will be considered, but they won't prevail, generally speaking, over unrelated creditors. Now, the way that story played out is the company goes into liquidation following our client's application. Our client decided to fund the liquidator to investigate the transfer of these trademarks. It was something that he knew about. He knew that there was value there. He applied to the court and said, look, court, I want to fund this liquidator because there's $48 million of creditors who now want to prove, and I want priority for my claim. The court said, well, if you're going to fund, we'll give you that priority. So there's actual mechanisms whereby you can elevate your priority in a liquidation if you want to take that additional step. It worked out very nicely for our client in this case. He ended up getting 1.5 million plus his costs, so I think it worked out to be about 96% of his claim. It was a slog, but this was something worth fighting for him. It was $1.5 million. He knew, he had the information, it was clearly an abuse. He got his just rewards. Second matter was, I think we wrapped up last year, matter of Citadel Financial Corporation. Our client won a case at trial. We successfully opposed an appeal to the full federal court. The day the judgment came down from the full federal court, the debtor company went into administration. So that was literally within hours of the judgment coming down. So we were, our happiness at winning the appeal kind of was quickly popped. So anyway, same situation, deed of company arrangement comes up. Now under this deed of company arrangement, it was structured in a way that effectively what was going to be paid to the creditors would be reduced by the administrator's fees. The effect of that was that whilst on paper the administrator said, oh, it was a great deal, we're going to get I think 2 cents in the dollar, that was always going to be zero because his fees were going to take it out. Now in this case, unfortunately, the administrator effectively acted as a tool of the director or was very much aligned with the director's interests. The report was terrible, as I mentioned before. He omitted proper reference to a lot of claims that be available in the liquidation, and it was left to the two key unrelated creditors, ourselves and the ATO, to grapple with this. So the deed of company arrangement gets up, surprise, surprise, and the ATO agrees to fund our client to terminate the DOCA. Unsurprisingly, in those circumstances, the DOCA was set aside again. Indeed, in the middle of the trial, the administrator decided that he best change his position, and he actually flipped on the company and said, no, I actually think that this company should go into liquidation. He did that entirely out of self-interest. The writing was very much on the wall, and he realised that he was going to face some heavy criticism. So, good decision for him. In summary, the court said that the only significant creditors who would benefit from the DOCA opposed it, namely our client and the ATO, and all the creditors associated with the DOCA would receive no benefit apart from the collateral advantage that they had by way of their relationship with the company. And the DOCA did nothing to promote the continued operation of the business. There was no plan for this company to keep trading afterwards. It was purely a device used to dispose of our client's claims in a cheap way. So whilst the liquidation on this one is still in its early stages, there are some significant claims there. The ATO is funding it, so they clearly think it's got merit, and we think that that one will see a good outcome as well. So that's two quick examples. Now, I know we're short on time, so I'll wrap it up, but earlier I talked about the fact that the reality is, as fun as these things sound and attractive as they may be, if you've got a big debt, they aren't cheap. But I think there's a lot to take away from what Nick said before of being the noisiest creditor. So even in situations where it may not be 100% commercial for you to think about going all the way to trial or hearing with something like this, if there's a DOCA that is foisted on you or looks like it's going to be foisted on you that you don't think is fair or don't think fairly reflects the financial capacity of the company to pay, there's an opportunity to make some noise. In our experience, a couple of really well-timed letters or approaches to the director or whoever's putting up the DOCA can often relate in one of those side conversations where they say to you, hey, can you just tone down the noise? We don't want any other creditors getting on board here. Tell you what, we'll give you a much better deal than they are going to get. You're still not happy, you're not getting 100 cents in the dollar perhaps, but that's a better outcome for you than just simply allowing the DOCA to go through. So it's really about thinking about opportunities where you can leverage things like this to try and secure yourself selfishly a better outcome. And in those really serious situations, you may want to band together with some of your colleagues in the BICB who may also be affected, or some of the other creditors, and go, no, actually, we want to do something serious here, and maybe bring such an application. So keep that in mind. It doesn't cost anything to pick up the phone to Nick or I and bounce something around, or flick us a report to have a look at and say, guys, do you think this looks right? We've got a problem with it. Could we make some noise here and see if we can get something done? So takeaway points, I guess, look critically at any deeds to company arrangement, read the report to creditors, and if you think something doesn't seem right, investigate it. It's worth looking at. If you are really dissatisfied, you do have powerful rights. The case law has evolved to the point that unrelated creditors in particular will be protected, and there are options to force these companies into liquidation and make sure they're scrutinised. Finally, related party rule, it's going to keep happening. Particularly again with this lead time and the idea that people have had time to set up these sort of deed to company arrangement scenarios that can be abused. We think it's going to be a pretty hot topic over the next 2 years. Not over the next 2 months, but yeah, with that longer lead time, and as these start to come into place, we'll think it'll spark up a bit. So look, that's all I wanted to talk about today. Were there any questions from the room at all? No? Anyone playing along at home, feel free to flick me an email or give me a call. Happy to have a chat, but otherwise, Wayne, thank you very much.